Contract of indemnity, and its essential elements. Definition: a contract of indemnity is a type of contract in which one party, the indemnifier, promises to compensate the other party, the indemnified, or indemnity for any loss or damage incurred due to the actions or omissions of the indemnifier or any other part. Purpose: it is commonly used in various commercial and insurance contexts to protect against specific risks. Know of parties: there are two parties to the contract of indemnity, i.e. indemnifier and indemnity holder. The person who promises to protect another from a loss is called the indemnifier. The person who is so protected is called the indemnity holder. Essential elements of a contract of indemnity: contract, written or oral; purpose, legality of object; parties involved, promise, consideration; loss or damage, accidental; liability of indemnifier; enforcement, scope and extent. 1. Parties involved: there must be at least two parties, the indemnifier who promises to compensate, and the indemnified who is to be compensated. 2. Promise to indemnify: the core of the contract is a promise by the indemnifier to compensate for loss or damage. This promise can cover losses due to various causes such as accidents, breach of contract, negligence, etc. 3. Loss or damage: there must be a specific potential for loss or damage that the indemnified party might incur, which the indemnifier agrees to cover. The loss must be clearly defined or definable. 4. Consideration: like all contracts, a contract of indemnity must involve consideration. This means there must be something of value exchanged between the parties, such as a premium paid in an insurance contract. 5. Legality of object: the purpose of the indemnity must be legal. The contract cannot cover illegal activities or actions contrary to public policy. 6. Scope and extent of indemnity: the contract must clearly outline the scope and extent of the indemnity. This includes specifying what types of losses or damages are covered, any exclusions, and the limits of liability. 7. Written or oral agreement: a contract of indemnity can be either written or oral. The written contracts are more common and enforceable, particularly in formal and commercial contexts. 8. Liability of indemnifier: unlike a guarantee, where the guarantor's liability is secondary and contingent upon the debtor's default, in an indemnity, the indemnifier's liability is primary and independent. 9. Enforcement: the indemnified party can seek enforcement of the indemnity contract as soon as the loss or damage occurs, without needing to wait for the indemnifier's failure to act. 10. Accidental: the damage or loss should be accidental, not intentional. Examples of indemnity contracts: insurance contracts. These are the most common forms of indemnity, where the insurer promises to compensate the insured for specific losses, for example, health, property, or liability insurance. Business contracts: in many business agreements, parties include indemnity clauses to protect against potential losses arising from breaches of contract, negligence, or other specified risks. Employment contracts: employers may indemnify employees for actions taken in the course of their employment, provided they were acting within the scope of their duties. Understanding these essential elements ensures that the contract of indemnity is properly structured and enforceable, providing the intended protection and compensation for losses incurred.